Good morning. My name is Jeff Pomerance, and I head up the transactional practice at Sulmar-Kupitz. Sulmar-Kupitz is one of the premier business, financial restructuring, bankruptcy, litigation boutique firms with a legacy of nearly 65 years. Our attorneys bring specialized expertise to our clients and cases, representing buyers, sellers, issuers, investors, lenders, debtors, creditors, trustees, receivers, committees, professionals, and just a whole lot more. We have offices in Los Angeles and Newport Beach, and I welcome you today. I want to also, before I begin, thank the folks at Burbay Marketing who do a really great job and who have assisted me today. Thank you for joining me this morning. I'm really excited to share with you today some insights and recommendations concerning protecting buyers in business acquisitions. These are insights and recommendations I've gleaned, developed over more than 28 years of experience representing individuals and businesses in a broad variety of acquisitions, joint ventures, dispositions, turnarounds, restructurings, providing general corporate representation and financing, and doing this in a wide array of industries, whether it be healthcare, technology, services, manufacturing, and retail. I've been on all sides from the standpoint I've been in the role as an accountant, as a CPA when I worked at Arthur Andersen. I've done mergers and acquisitions attorney work in Chicago and in Los Angeles. I've been a corporate officer of a venture-backed technology company, and prior to joining Sulmar-Kupitz, I was a COO and general counsel of a venture-backed incubator focused on early and middle-stage investment opportunities, primarily in entertainment, sports, and technology-related fields. Hopefully you have before you a presentation, a PowerPoint presentation that I've assembled for today's webinar. I refer to, please refer to it as we go through. Too often buyers and buyers of businesses mistakenly feel that they simply carrying out the acquisition in the form of an asset deal. That's just put language in there that excludes any liability, and I'm protected, right? Well, if the answer was right, this would be an awfully short webinar. The reality is it's not. I will try and limit myself, but there are a myriad of horror stories that come to mind. Too often I've seen situations where someone has come to me after the transaction has been papered and said, I don't understand. The agreement says that I'm to pay $500,000, $1 million, $100,000, whatever the number is. And yet I'm now hit with this bill, or someone's called me and I owe a lot more and I didn't budget for that. And that can happen, and certainly does, even when you have these asset deals with limitation language. So this isn't the case. I want to talk to you today and highlight today's goals. I want to provide you a bit of background about the issues. Then I want to provide an overview of potential liability considerations for acquirers that arise when they are conducting a business acquisition. Then I want to identify some potential concerns over another area that's kind of aligned with this, what I call hidden claims that can affect the deal. And lastly, I don't just want to give you a taste of it, I want to offer some solutions and strategies so that you can help yourself and help your clients through these potential problems. As you'll see, I have an outline that I will attempt to follow in the next hour or so that kind of goes through some of these points. So let's begin. On a very kind of introductory basis, often you hear the word, the deal has got to get done. And I think it's important to take a step back from that and recognize a couple of things. First off, a deal or an acquisition is really indeed a process and not an event. It simply doesn't happen because you want to do it right now. In fact, I would suggest that in almost every deal I've ever worked on, you don't want it to be an event. You want it to be a process, and you want to be active in that process. Of course, as an advisor and in an acquisition, you need to be sensitive to costs and timing. One of the key phrases that we hear in transactional work is the time is not your friend, and it's true. Another point to address is the recognition of what I call the value proposition and opportunity costs. the value proposition in my mind is when you represent a buyer, what are they looking for? Why are they doing this deal? What is it about this deal that makes them want to expend time, money, energy, commitment, and engage in the process? It's very important, I think, to properly advise buyers and acquirers that they need to understand and then articulate to you so you understand the value proposition. You also need to appreciate the opportunity costs associated with that. In other words, there are many times where if I don't do this deal now, I may not have a chance to do it again or do a deal like it later. So those are issues that have to factor into the quote-unquote, the deal's got to get done. And third, I'd like to just touch on the idea of appreciation, the role of the advisor. There's an expression that I have when I'm dealing with client transactions where I talk about making sure that the tail does not wag the dog. What I mean by that is that too often we can get lost in our own little focus. In my case, advising clients wanting to make sure that they address the legal issues. One needs to bear in mind that there are other considerations besides simply legal that really are necessary to address if you want to adequately help your client. And again, I think one of the keys in the role of an advisor and appreciating that role is appreciating that the ultimate business decision is the client's, and what you want to do is offer up the best available information to advise them, assist them, address issues, but the ultimate decision is theirs. And what that requires of you is that you understand your client, what they want, their proclivity for risk, and their unique concerns. So I hear this all the time. Jeff, it's not a big deal. Don't worry, it's not a big deal. Here are three, I've kind of noticed this over the last couple of years. Here are three of my favorites. Jeff, what's the problem? This needs to get done now. We don't have time. Or, don't worry about it. I know the business and the management. There's nothing to worry about. Third, this is not a big deal. This isn't a $10 million deal or a $50 million deal. It's a relatively small deal. Why are you so concerned? Well, as I'll allude to later, I'm concerned because I want to make sure that my clients achieve what they want and then hopefully even exceed their expectations. And so, it's not a big deal. I understand. One of the things also to address along those lines is who's driving the deal. I think it's important to note that people need to understand their bargaining position and what market factors exist. Are there other bidders out above, or is the seller simply saying we have to get the deal done now? All of those factor in to addressing the concerns of a buyer in an acquisition. And third, along those lines, and this is the second part, until it is, it's not a big deal until it is what can be done. Once the documents are signed and the deal's closed, it generally is not much one can do, at least not in a transactional capacity. However, what I hope to at least kind of highlight or share is after negotiations have begun, but prior to the document being drafted or the closing, many times by bringing your advisor, your attorney into the process as a buyer or buyer's counsel, what you can do is you can get what I call the push leverage, and meaning parties already negotiated the deal and they're uncomfortable about the idea that you're going to renegotiate. A lot of times what will happen is during this middle area about after negotiations or prior to closing, sometimes your advisor, legal advisor, can be effective in highlighting issues and restructuring some of the deal, and certainly the good cop, bad cop, for offering solutions, and if they're not acceptable, the parties can still kind of call off the attorneys and go forward. Again, what can be done? The best thing, and what I hope to suggest through the presentation today is at the outset to bring in an advisor to make this an opportunity where the buyer goes in with their eyes as wide open as possible. along the lines of managing expectations, I want to make sure I express what you will not hear today. You're not going to hear simple solutions. Just use this form, because I don't know of any. You're not going to get a complete list of all potential claims against buyers, whether it be things like the WARN Act, which I was just looking at earlier. WARN Act relates to the Workers' Adjustment and Retraining Notification Act, which protects workers in the event of notification of closing of facilities or loss of employment. You're not going to hear about the WARN Act. You're not going to hear about other federal and many state laws. Third, you're not going to get here today a guarantee of outcomes. If you don't want risk and you're not willing to take any risk, then chances are you may not want to or shouldn't do a deal. There's inherent risk in any opportunity, and what our goal is to try and manage and address those and mitigate as much as possible those risks. So if there's a guarantee that I'm going to suggest today, it's a guarantee of process, but certainly not of outcome. Lastly, the specific deal structuring recommendations. It's important to note, as you'll find out as we go through the substantive part of our discussion today, that many of these issues are very fact sensitive. And one size really doesn't fit all. You need to tailor this to the unique situation of your particular client. Okay, now let's get into a little bit of substantive discussion concerning today's presentation. The areas I've addressed in this presentation, PowerPoint presentation, which I hope now to share with you, are more general areas for discussion. Believe me, there are many, many more. I believe it makes sense to single out these 6 general areas that you need either as the buyer or as the buyer's trusted advisor to be careful about as you look to do an acquisition. These 6 categories are as follows. Number 1, common law and product line liability issues. Number 2, California statutory tax withholding and liability issues. Number 3, hazardous waste disposal liability issues. Number 4, collective bargaining obligation issues. Number 5, bulk sales law issues. And number 6, Uniform Fraudulent Transfer Act issues. As we begin to drill down on each of these, please bear in mind that some, many, or even most may not apply to your deal or any specific deal. However, as you will see, if you do not recognize these potential hooks that can expose a buyer to liability, you may very well find you as a buyer or your client, if you are their advisor, having to deal with potential liabilities that frankly you did not bargain for, and certainly you may not have accounted for in creating the value proposition for doing this deal. And again, I'm mindful of a transaction where I was the seller's side counsel on this, but a $500,000 deal, yet the buyer recognized that there was potential exposure for up to $2 million of trailing liabilities. This is a terrible outcome for a buyer, and it's something that, again, I would like to discuss with you now so you could advise your clients appropriately. Okay, let's begin with common law principles. As a matter of common law, the buyer in an asset transaction is not generally liable for the debts of the seller unless, number 1, the buyer expressly or impliedly assumed the obligations in the documents. Number 2, the transaction constitutes what they call a de facto merger. Number 3, the business operated by the buyer is so closely related to the seller that it's considered a mere continuation of the seller. Or number 4, the transfer of assets to the buyer is for the fraudulent purpose of escaping liability for the seller's debts. This is very important, and the reason I start out with it is kind of stepping back for just a second. There are many ways that you can acquire rights and acquire companies and businesses. Certainly, a stock transaction where you acquire the equity of a company is one. Most buyers choose not to do that from the standpoint that they step into all the liabilities, not personally perhaps, but certainly their acquisition retains those liabilities of the company prior to the acquisition. And again, so often there are liabilities and obligations that pop up that you don't know about. So again, I don't even want to say a number, but the vast majority of acquisitions of businesses are in the form of an asset purchase agreement where you represent the buyer. It's important that in looking at this, at least in making a recommendation, the final determination in each case depends on the unique facts of each situation. I think it's important to note that in all these things, that cases look at form and substance. It's not simply, and that's what some of these things mentioned touch upon. Cases have found they acquire liable in the context of mere continuation, as an example, when there were certain facts present, including inadequate consideration for the payment of the assets, or one or more persons or officers were directors of both entities. So what I'm suggesting here is when you do an asset transaction, the asset deal, while more protective, it needs to really have the right substance as well as form. And this speaks again, in part, to the documentation. As noted, you certainly want to expressly exclude those liabilities that you don't want to find waiting for you on the closing date if you're a buyer. Now, interestingly, I want to just kind of touch on something very briefly, but I think it's relevant to note that in 1977, the California Supreme Court, in a particular case, imposed liability for defect claims related to products sold by a dissolved predecessor. Again, it was certain limited circumstances. But I mention this because if your deal involves manufacturing, in addition to the asset and other things we're going to talk about in an asset transaction, you should pay particular attention to what they call product line liability considerations. And as you'll hear quite often in this process, you need to really do your homework. Now, I want to touch on some unique things from the state of California that I've referred to as California statutory tax withholding liabilities. Number one, the first one is the California sales and use tax. Purchaser of a business as its successor is required by statute to withhold a sufficient portion of the purchase price to cover the seller's liability for California sales and use taxes until the seller produces a Board of Equalization receipt for full payment or a certificate indicating that no amount is due. This is California Revenue and Tax Code section 6811. This liability includes not only taxes from the sale of assets to a buyer, but also taxes from prior sales made in seller's business. So if you're buying a division of a company that has multiple divisions, this may be something you want to look at very carefully. Failure to withhold may result in the buyer, and again I stress, the buyer being held liable for seller's taxes to the extent of the purchase price. And that's addressed in Revenue and Tax Code section 6812. The buyer may request the Board of Equalization to issue a certificate indicating that no tax is due or the amount of tax payment required for the certificate issuance. The Board must issue the certificate or state the amount due within 60 days after the latest of number 1, the date the request is made in writing, number 2, the business sale date, or number 3, the date when the seller's records are made available for audit. And this is, again, in Revenue and Tax Code section 6812. So that's one example where a buyer can be liable for seller tax liability. Another example is unemployment payroll taxes. In California, the purchaser of substantially all the assets of a business is required to withhold a sufficient amount to cover the predecessor's employer's due or unpaid contributions, interest and penalties to the California Unemployment Fund, Unemployment Training Fund, and Unemployment Compensation Disability Fund until the predecessor produces a certificate indicating that no such amount is due. Absent such a certificate, the purchaser may be required to pay the withheld amount directly to the California Employment Development Department, the EDD, according to Unemployment Insurance Code Section 1731. The department must issue the certificate or a statement indicating the amount due within 30 days after a request by the seller or buyer. Failure to do so releases the buyer from liability under Unemployment Insurance Code Section 1732. In another instance, the Franchise Tax Board relating to income taxes, pursuant to California Revenue and Tax Code Section 18669, a purchaser of a business or a substantial portion of its assets must withhold a sufficient portion of the purchase price to cover the seller's taxes required to be withheld under California franchise and income tax law, plus interest or penalties, until the California Franchise Tax Board, or the FTB, issues a certificate indicating that no taxes, interest, or penalties are due. Failure to so withhold may result in the purchaser being liable for the amount owed by the seller, but not exceeding the fair market value of the business or assets purchased. Within 60 days after a purchaser's written request, the FTB must issue a statement showing the amount due or a certificate indicating that no amount is due. If the FTB indicates that an amount is due, the purchaser must pay it within 30 days when the business or assets are purchased. This is important. If no request is made, the purchaser must pay the amount due on the date the business or assets are purchased. The purchaser, again, must pay that. Failure by the purchaser to make payment when due also triggers a 10% penalty. I had a transaction a number of years ago where I did not represent the buyer or seller, but a party of interest. And we were trying to address the concerns that the buyer had failed to take appropriate action. And again, as it's noted here under Franchise Revenue and Tax Code Section 1869, a purchaser is responsible for seller's taxes that should have been withheld relative to income taxes due to the Franchise Tax Board. And it was not an insignificant amount. So those are, forgive me, jumping ahead a bit. Those are, again, 3 examples of how California, through the withholding and taxing power, can impose a liability on a buyer even if you have an asset purchase agreement that says, I, buyer, do not assume any of these liabilities. But I want to go further and now touch on some additional things that I've seen over the course of transactions that I've worked on. One in particular is hazardous waste and disposal liabilities. A buyer's successor liability for the seller's hazardous disposal and cleanup obligations under the Comprehensive Environment Responsive Compensation Act of 1980, the CERCLA Act, can result in a buyer being subject to liability for successor environmental issues if there are chemicals involved in a business, and even in service businesses there can be chemicals involved. One should give consideration to the potential exposure for environmental liability. And we all know that in a real estate transaction, this is certainly a prime consideration. But even in a non-real estate transaction, depending upon where those chemicals are being dumped or how they're being discharged, the buyer under CERCLA may have exposure, even though in the asset purchase agreement, again, it says contractually you don't. The statute supersedes that. So that's something to bear in mind. I saw a transaction involving a laundry cleaning service, a laundromat. And in their starching and processing, there are a number of chemicals that flowed into a drain and then out, and there was leakage. And the buyer was liable in that transaction, but was able to get coverage on an indemnification. But there was exposure there to the buyer. Another area to pay attention to or be concerned about, potentially, is collective bargaining obligations. Courts have found successor buyers liable in certain situations relating to liabilities under collective bargaining agreements negotiated by the predecessor seller. Again, this may not be applicable to you unless your seller has had a prior union or collective bargaining agreement. I've worked on transactions before, and candidly, I've brought in firms, one in particular, Littler Mendelson, that represents management side, that did a great job of fleshing these out. You may think, in the deal we looked at, we noticed that there wasn't in place a collective bargaining agreement, but there had been. And it was through working with them that we made sure that we addressed that liability. One of the next ones is one of my favorites because it's so prevalent in almost every transaction. I'm referring to the California Bulk Sales Law. California Bulk Sales Law, which is found under Commercial Code sections 6101 to 6111, applies to a bulk sale by a seller engaged in the principal business of selling inventory from stock, including those manufacturing what is sold, even a restaurant under Commercial Code 6103A1. The seller must be located in California. The bulk sale is defined to apply to a sale of more than half of a seller's inventory and equipment, measured by value, and that's addressed in Commercial Code section 6102A3II. So the sale of an entire business, including inventory, is almost always a bulk sale. There are certain exempt sales, including a sale of less than $10,000 or more than $5 million under Commercial Code 6103C12. And that's generally where parties find protection under the above $5 million. But if you're between $10,000 and $5 million, California bulk sales laws may indeed apply to you. If applicable, the following duties of compliance with the bulk sales law are imposed on the buyer by statute. And again, I stress on the buyer. You have to obtain from the seller, number one, you have to obtain from the seller all of seller's business names and addresses for the prior 3 years. Number two, you have to give a notice of the bulk sale. And number three, applying consideration of sale, if less than $2 million in satisfaction of claims, you have to kind of reserve for that. You have to apply the consideration, kind of hold back or reserve for that. The code provides for the content to be included in the notice of sale, and that the buyer is obligated at least 12 business days prior to the bulk sale to record the notice with the county recorder, publish it in a general circulation newspaper, and deliver it to the county tax collector with a completed business property statement in the designated jurisdiction in which the tangible assets are located. Failure to comply with the bulk sale law requirements may subject the buyer to a claim for damages by the seller's creditors, subject to defenses and a maximum liability of buyer under, as more fully stated under Commercial Code section 6107D. Now, California bulk sales, again, it involves in almost every instance where it's all or substantially all, but at a minimum, more than half of the inventory measured by value. It's not a transaction, it's not applicable in transactions of under $10,000 or more than $5 million. But if it is, as you can see from this, you have a lot of work as a buyer to do to make sure that you comply. In almost, not in almost every instance, in many, many instances, there's significant pushback, either from the seller or from the buyer. The seller wants to close the deal fast. They don't want to wait this time. At least 12 business days means you should wait longer than that, because what you're really trying to do is provide all the creditors with notice so that they know that you are acquiring this business. Many times in transactions in which sellers don't want to do this, the concern that I have is not representing the buyer, but representing other claimants. Who are they selling it to? In those instances in which sellers try to evade certain obligations, they'll do a transaction to an affiliated party, different company name, different corporation. It goes back to what I talked earlier about the mere presence under common law of form and substance. But you have to be very careful in bulk sales law because it does expressly requires the buyer to undertake a number of things. Buyers don't like to do this because, again, the 12 days may be a problem, and there's a lot of steps here. And I certainly understand that, and as with many things when working on transactions, the goal is you bring this issue to the buyer's attention and you try and work through it in the best ways possible. But it's important, very important, that on deals involving inventory, deals of less than $5 million, that you be very mindful of the implications of the California bulk sales law. The next thing I want to kind of touch on, and again, this is a part of a much broader discussion, is what they call the Uniform Fraudulent Transfer Act. Under California's Uniform Fraudulent Transfer Act, which is Civil Code sections 3349 to 3439.12, a transfer of assets is considered fraudulent against the transferor's existing and future creditors, either as an actual or a constructive fraud. Under the statute, a transfer of assets is considered constructively fraudulent, meaning there's not actual fraud, but it's deemed to be fraudulent, to the transferor's existing creditors if the transferor did not receive reasonably equivalent value for the purchased assets and was insolvent at the time or became insolvent as a result of the transfer. This is discussed in sections 3439.05 of the Civil Code. To address this concern, among other things, buyers typically pay for a reliable appraisal. Of course, they look at the financials, and they use that appraisal to establish the reasonably equivalent value. In a slightly related area, under Civil Code sections 3440 to 3440.9, subject to certain exceptions, a transfer of personal property not accompanied by immediate delivery and not followed by an actual or continued change of possession is considered by the transferor's creditors and subsequent bona fide purchasers for value. It's considered void, I'm sorry. So what does this mean? Number one, you got to be very careful when you're acquiring something. You know, often buyers will come to me and say, I got a great deal. Great deals are fine. Too great a deal can be problematic. Again, there are many other factors that are involved, but when you don't acquire assets for reasonably equivalent value, you should certainly, as a buyer and certainly as buyers, advisors, counsel your clients what's going on, why. This reasonably equivalent value issue generally ties into the fact that, as noted, the party's insolvent. And too often, companies that are having very difficult times want to get out from secured claims or other claims. They want simply kind of cut, whether it's a division or business or assets, and do it as quickly and just get it done. Those are the situations where you need to be extra careful. Again, ask yourself, if you're getting a deal that's a good deal, why? And if it's a good deal, is it too good a deal? And always, when you can, try to seek some level of independent appraisal in case the deal is a good deal and you want to protect yourself from future claims. Okay, so those are some of the issues, substantive issues, that, again, candidly, you could have an asset purchase agreement, you represent the buyer, it excludes all liabilities, and yet you could be on the hook for all kinds of things that we've just discussed. I also want to talk to you a little bit about what I call hidden liens and claims. As I hope you can kind of sense, there are a myriad of potential claims that may attach to assets you purchase. What does this mean for you? Well, it means you bought seller's rights, but you may still owe, whether it's money or other things, you may still have some obligation to someone else that you didn't contract with. but nonetheless has what they call a superior claim to the asset you bought. Now, of course, candidly, you may have a right of action. You may have a lawsuit against the seller. But for a myriad of reasons, not the least of which I'm a transactional attorney, and I don't think lawsuits make a lot of sense from a business perspective, our job is to avoid those and to protect you so you don't have to initiate a lawsuit. So what is this hidden lien thing? Well, first off, let's talk about non-hidden liens. Some liens are public. For instance, Uniform Commercial Code and secured transactions. You can go in the Secretary of State's and do a search and find UCC recordations. These are voluntary liens that have issues regarding priority. They're addressed in the Uniform Commercial Code. If you buy an asset or a business that has recorded liens, you take those assets subject to those liens, which means that even though you don't assume the loan, let's say that those liens were in conjunction with a loan to the seller, if you don't assume that loan and the seller defaults, one of the things that the UCC permits is for that secured lender to attempt to seize your assets. So there are liens and claims that are public. There are also, looking at here, there are also judgment liens, county level, and there are other types of liens, for instance, in certain intellectual property, U.S. Patent and Trademark Office, that you can look at, so you can be put on notice. But there are other liens that are not recorded. And many liens, in fact, are what I call hidden, which means they're not readily ascertainable without due diligence. Now, I know you can't see this. I have a book that's well over 100 pages of hidden liens. What are these? These include things like banker's liens, liens for warehousing and storage, carrier's liens, other liens for services. For instance, there's a hotel keeper's lien under Civil Code Section 3051. There's hospital liens for emergency and ongoing services under Civil Code Section 3045.1. You wouldn't believe the amount of liens arising in litigation. There's agricultural liens. And there are what I call possession considerations. Possession considerations under the Uniform Commercial Code. There are certain types of assets where if someone has, I've lent money to someone and I took back what they call a bearer instrument, for instance, or I took cash and held it in my account. I have a lien and claim in that asset, and you can do your UCC search, and hopefully you'll see that the person has, the secured claimant has in the case of the possession lien, you will see something, but you can't rely on that. My point is there are all kinds of things, and again, you wouldn't believe, just going through this, liens for products, services. As I mentioned before, this warehouse, what does that relate to? Carrier's liens, it means that items are in transit or held in a warehouse, and the warehouseman has a right to be paid prior to you getting this asset. So here you are, you have an asset purchase agreement, free and clear, and it turns out it's not free and clear. These are problems. And I want to touch on one other thing, just because we live in California, which is a mecca of technology, and there's tremendous opportunities in technology, licensing, intellectual property. And then there's license rights in technologies. You have to be very mindful and very careful when you're buying a business to understand if your client is acquiring license rights in certain technologies and certain intellectual property. There's nothing recorded, but you have to look at those licenses and understand that they may or may not transfer, notwithstanding whatever, notwithstanding what the asset purchase agreement says. It's extremely important because in many instances, especially with technology companies, the failure to get these rights guts the value proposition that you seek to attain. Okay. So now you've heard kind of the lay of the land, a bit of doom and gloom. I'd like to suggest in the last 15 minutes or so, maybe less, some solutions. It's not enough just to say there are problems. What are we going to do about it? Number one, I can't stress this enough, due diligence. You would not believe how important due diligence can be in assessing the potential for these issues. Now, due diligence, doing the homework, not just meeting with, but looking at the documents, engaging the proper professionals is vital. But I want to stress, it's not perfect. If done properly, what it can do is highlight issues, lead to further discussions, lead to structuring that may better protect a buyer, and, of course, at a minimum, address the concerns that I've just raised. But I'm cognizant, as I mentioned at the outset, that the issue in due diligence is generally timing and cost. It's expensive, and there may not be sufficient time. And that's a problem, and it's a very big problem that those of us that advise clients are constantly sensitive to. And there's a balance. Too often, when we learn about something, it's at a point where we don't have time to necessarily pivot and address it. So again, in a perfect world, due diligence is a must, and you have to allow sufficient time for it. Along the lines of timing, the sign and closing. I refer to this as kind of known as the buying time opportunity. Think about real estate transactions where there typically is a due diligence contingency. In many of the real estate deals that we do, there's a set amount of time for the buyer to do all the due diligence they need to make sure that they are buying what they believe they're buying, and so they have that kind of comfort level. This approach, I think, is important to consider adopting in the asset transaction involving non-real estate, tangible as well as intangible personal property. It's interesting. It's a way to tie up a deal while you continue to study the business for these types of claims. So in those situations where timing is sensitive, in many instances, I'll suggest, why don't we do a sign and a due diligence contingency and a close? Now, the advantage is, again, you tie up the deal, and you have a chance to study. The disadvantage is generally you have to put up some good faith deposit. But let's think for a moment, going on some of the things we talked about dealing with, for instance, sales and use taxes. There, as we talked about, the buyer can request the Board of Equalization issue a certificate indicating that no tax is due or amount of tax payment required for the certificate issuance. And the board has to issue that certificate within 60 days after the latest of certain dates, whether it's the date request, business date sold, the date when the seller's records are made available for the audit. So in that context, sales and use taxes, maybe you push off the closing. You sign it, but you push off the closing to allow you to get that certificate. How about unemployment payroll taxes? We discussed the EDD must issue a certificate or a statement indicating the amount due within 30 days after request. So again, if you're concerned about that, sign and close with a 30-day, at least a 30-some day, more than 30, but 35-day window to close. How about what we discussed earlier with the Franchise Tax Board, income taxes? As I mentioned, within 60 days after a purchaser's written request, the FTB must issue a statement showing the amount due or certificate indicating that no amount is due. If the FTB indicates an amount is due, the purchaser must pay it within 30 days when the business or assets are purchased. So in that context, what that would suggest is that we have a certain period of time, more than 30 days. If you see that that amount is due, then the closing is contingent on the seller satisfying that amount within the stated time. And lastly, one more example is the bulk sale. We talked about 12 business days, the record notice with the county recorder and all the publication. Again, if you are concerned or at risk regarding bulk sale, then certainly you want to have the time to effectuate addressing these issues so that you have a comfort level. You know what the liability is by the statute itself. And along those lines, tying that together, the next point is holdbacks. Again, kind of stepping away from it, these are solutions or ideas that one should think about in terms of best protecting acquirers. Holdback is, as it sounds, the buyer does not remit some of the purchase price at the closing and holds it back to pay it at a later date upon the satisfaction of certain events. This is buyer's potential cushion. It's not perfect, and it may not be sufficient. As I've said, I've seen situations where the purchase price can be less than the stated purchase price, can be less than the actual liability and obligation of the buyer because of these hidden liens and other trailing liabilities. So it's not a perfect solution, but it does give you some cushion or comfort. And it's easier from the buyer's perspective to not pay the money than to have paid the money and then have to seek it back in a lawsuit or action. So I've used holdbacks in many situations. Again, there's a sensitivity. The buyer sometimes is concerned that the holdback, that the seller is concerned the buyer may not perform. In those cases, sometimes you put the holdback in an escrow. The point is, you don't pay it to the seller. And again, if you've done due diligence and have a sense of some of these issues, sales and use tax, unemployment payroll, franchise tax, sport taxes, you hold back the amount that you reasonably believe may be at risk so that no one can knock on your door and ask you to fund an additional amount beyond what you've agreed to fund. The next option, when sometimes holdbacks aren't acceptable, is in the form of a promissory note. In other words, the buyer has cash, the purchase price is effected through cash down and a promissory note. What does this involve? Well, number one, the seller generally feels better than holdback because the buyer is directly on the hook. I mean, the money isn't in the buyer's hands, isn't still in the buyer's hands, and they are obligated to pay all that amount. It can have the same result, and that's what we try to achieve in terms of protecting buyers, especially if it has what they call offset rights. And what's also helpful is the promissory note allows you to structure the transaction in ways that, although this is not I'm not focusing on tax issues, but nonetheless, you might be able to focus to use a promissory note to achieve some beneficial tax implications. But again, the concept is that you are not paying money out of pocket that you find out that you need to then go back to the seller and claw back or recover. The next one to think about is what I call third-party support. Now, this can include standby letters of credit, pledges, guarantees, side letters, sometimes side letters with potential claimants, what I call comfort letters. Of course, you can't have these side letters with government agencies, but the idea here is that you get some level of comfort and try and get your arms around what the potential exposure is of a given issue. So for instance, if you're concerned about paying money, you know that the buyer is having difficulties, you're worried about an insolvent seller, or the seller has difficulties, you're worried about an insolvent seller. As a buyer, you know that, number one, let's say all the cash proceeds that go to the seller will then be paid to the creditors and claimants, and the ultimate seller will have no cash available if there's one of these, liabilities that spring up post-closing. So where do you get comfort or protection? You look to insiders, you look to other parties, you look to something that gives you some ability to seek recompense because it won't be from the seller. And again, we do, at Summer Kupitz, we do both sides, if you will, both sides of the river in the sense that we do insolvency, restructurings, turnarounds. We see those types of deals, and we do the early stage startups, healthy companies as well. But in a lot of instances, it doesn't hurt to at least look for, seek, and maybe sometimes obtain some sort of third-party support. Okay. Well, again, I want to kind of follow up on suggesting that the key here is developing a strategy. And again, I hope what I'm trying to kind of address through this presentation is you first need to recognize the potential problem. And I hope today's program has been helpful in giving you what I would call a good survey on the potential pitfalls and concerns. Like any survey course, and I'm thinking, you know, the college course, high school course, where you do American history and you're supposed to know all revolutionary history in 2 weeks. You now have a taste, smattering of some of the issues. And I would encourage you, to the extent that you're interested, or to the extent that it's relevant and applicable, and I believe it is, to my listeners, that I would suggest that you really drill down further into the substantive issues involved. Having said that, I hope, and I wanted to provide you with an approach or strategies to address and protect these your clients as acquirers, or yourself as the acquirer. Here goes. Number one, do your homework. Again, I cannot stress how important due diligence is. Due diligence is really a key here. Number two, timing is essential. The earlier the better. Later on, you get the discomfort of having to go back and renegotiate, which can pose problems. You've maybe lost good faith as a buyer if you want to redo the deal. And so timing is crucial. The key is to understand these issues and to start addressing them immediately. Number three, and this goes to what you won't hear about forms, you need to be creative. You need to develop solutions that work. I'll give you one example. I did a transaction a number of years ago where I was involved with principals. They were buying a company that had been in operation providing paint and related products and services, mostly product, for well over 50 years. And the concern obviously was, how do we protect on CERCLA, which is the fact that they've been dumping stuff for years and years and years. And what we ended up doing in that transaction was we did holdbacks, but we did more than holdbacks. We developed pods where, and it was complicated, but the pods involved holdback amounts as to specific sites where we knew that they had dumped materials. We were able to effect a transaction where the buyer was able to avoid any liability on CERCLA because monies were set aside for those programs, and only to the extent that it cleared the CERCLA issues were the monies then released to the seller. We were able to do this transaction. We didn't get indemnifications. We looked at the deal in particular. It was a nightmare of getting to it, but it was a tremendously successful acquisition. The client got the benefit that they were seeking, and they didn't have anyone knocking on their door because they addressed it through holdbacks. That's one example. The last thing I want to just suggest, which sounds kind of like a unique strategy, but follow your compass. Many buyers, especially buyers that are knowledgeable and understand the business, have a sense of value, have a sense of risk, and too often need to be advised that the ultimate decision is theirs and that they need to listen to that voice inside of them. Our goal is to help, to address, to try and minimize, but many, many times what I recommend to clients is you become successful because you've listened to your compass. Don't ignore that in this instance. Okay. It's funny. In conclusion, the best deals, I hear this often, the best deals are sometimes the ones that I did not do. I understand that, but I'm not happy about that. In my role as an advisor, I want to help you get the deal done. I want to attempt to identify and address the risks. I want to attempt to minimize those risks, and I want to help you as a client achieve the risk-return kind of ratio that you seek to achieve. And again, the goal is actually to surpass that. I'd really, instead of the concept best deals or sometimes the deals I didn't do, I would hope that really it would more accurately put the best deals are the deals I did and those deals that I chose not to do. Listen, we're wrapping up now. It's noon. I appreciate every one of you listening in. As I hope you can sense, I really enjoy helping people do these deals, figuring out the issues, closing, and hopefully exceeding expectations. It does not always happen, although lately I've been on a pretty insane hot streak, and it seems every deal I'm working on is closing. But again, you try to assist clients in approaching the opportunity and working to maximize the probability of success. I'm here to help, and if you have any questions or want to discuss any of the issues I've raised further, please don't hesitate to contact me. My contact information is the deck. And again, I very much appreciate all of you listening in. I understand we're going to be sending a copy of this PowerPoint presentation along with the CLE materials following the program today. This concludes the program. Thank you so much.